Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing this term's Supreme Court opinions likely to have the most impact on lower courts. I'm Beth Wiggins, Director of the Research Division at the Federal Judicial Center. For about the next 15 minutes, we'll discuss three civil procedure opinions. I'm pleased to welcome Erwin Chemerinsky, Dean and Jesse H. Choper, Distinguished Professor of Law at University of California, Berkeley Law School, and Evan Lee, Emeritus Professor at UC Law, San Francisco. Waetzig versus Halliburton Energy Services and BLOM Bank SAL versus Honickman involve Civil Procedure 60B motions for relief from judgment, and Lackey v. Stinnie, the award of attorney's fees of prevailing parties in civil rights litigation. Let's talk about Lackey v. Stinnie first. The question here is what happens when, after a preliminary injunction, the case becomes moot before final judgment on the merits is issued. Evan, can you take us through the facts, please?
Virginia used to have a statute under which drivers could have their licenses suspended if they had too many unpaid court fines or court costs. The plaintiff class in this case consisted of drivers whose licenses were actually suspended pursuant to this law. And they sued in federal district court under Section 1983, claiming a violation of procedural due process. They prayed for both preliminary and permanent injunctions against enforcement. The district court granted a preliminary injunction, but before the case could be tried, before any permanent relief could be awarded, the Virginia legislature repealed the law, thus mooting the case. Plaintiffs moved for an award of attorney's fees under Section 1988B, arguing our suit led to the resolution we desired, therefore we are prevailing parties. The district court denied that motion based on circuit precedent. But the Fourth Circuit en banc reconsidered its precedent and held that when a preliminary injunction provides the plaintiff with concrete, irreversible relief on the merits and becomes moot before final judgment, the mootness of the case doesn't preclude an award of attorney's fees. So that was the Fourth Circuit en banc. The Supreme Court reversed 7-2 with Chief Justice Roberts writing for the court. The court stated that preliminary injunctions do not conclusively resolve legal disputes. The purpose of preliminary relief, the court says, is simply to preserve the status quo while the litigation takes place. The standard for a preliminary injunction is likely success on the merits, not certain success on the merits, but likely success on the merits, along with the showing of irreparable injury, balance of the equities, public interest, etc. But it's nothing like a complete trial on the merits.
So, Erwin, how did they get there?
As Evan says, under Section 1988, a plaintiff gets attorney's fees in a civil rights case if the plaintiff prevails on the merits. Until 2001, it was always thought that if the plaintiff was the catalyst for legal change, that was enough to be a prevailing party. In Buchanan Board versus West Virginia, the Supreme Court rejected the catalyst theory. And I think this case builds on Buchanan Board, whereas Evan points out, the Supreme Court says, if the plaintiff receives a preliminary injunction, that isn't enough to be a prevailing party. Chief Justice Roberts stresses preliminary injunction is just that. It's not a final judgment on the merits, and therefore it can't be a base for saying that somebody's a prevailing party.
So, Evan, Justice Jackson wrote a dissent. I think she was joined by Justice Sotomayor. How did they see things differently?
She criticized the categorical nature of the majority's holding. She said there's no persuasive reason to believe that Congress meant to preclude fee awards for every plaintiff who secures preliminary injunctive relief, but not a final judgment, no matter the context. And it's that last clause, no matter the context, that really bothered the dissenters. They didn't understand why more couldn't be taken into account versus having this really bright line rule. And they ultimately said this holding is inconsistent with 1988's clear objective, which is to encourage attorneys to file civil rights actions on behalf of the most vulnerable people in society.
So what's important for lower courts?
I think the operation of this rule is pretty straightforward. As I say, it's a pretty bright line decision, but it's the impact that is unclear at this point. It could be devastating to the ability of plaintiffs to obtain counsel when the sought after relief is principally injunctive rather than monetary.
So, Erwin, anything you'd like to add?
I agree with what Evan just said. I think this is a very important decision because I think it's going to make it harder for plaintiffs to recover attorney's fees when they receive a preliminary injunction. Often plaintiffs receive a preliminary injunction that remains in force for months or years until there's a trial. Often the preliminary injunction causes the government to change its policies. In none of these instances would plaintiffs be able to cover attorney's fees. In fact, think of the most egregious government actions where the plaintiff sues for a preliminary injunction and wins at that level. And then the government changes its policy. The plaintiff isn't going to get attorney's fees in those circumstances. As Evan says, that might make it harder for civil rights plaintiffs to even be able to get attorneys.
In BLOM Bank SAL versus Honickman, the court decided that the plaintiffs did not demonstrate the requisite extraordinary circumstances that would allow them to reopen their case and amend their complaint. Erwin, can you explain the background of this case?
This was a suit against Hamas and against a Lebanese bank that was alleged to have supported Hamas's terrorist activity. These were events that occurred over 20 years ago. And the federal district court dismissed the suit against the bank, saying that there weren't sufficient allegations that it had knowledge of and was aware of the terrorist activities that were allegedly being supported. The United States Court of Appeals for the Second Circuit affirmed the dismissal by the district court. The plaintiffs then go and try to overturn that judgment pursuant to Rule 60B of the Federal Rules of Civil Procedure, and they want to then be able to file a new complaint. And Rule 60B outlines 5 circumstances in which a judgment can be set aside. And then 60B-6 says, as a catch-all, in the interest of justice, the judgment can be set aside. The district court rejected that argument, but the Second Circuit reversed the district court and found that the requirements of Rule 60B-6 were met in that it was in the interest of justice. And that's what came to the Supreme Court.
So, Evan, what did the Supreme Court decide?
The court, speaking through Justice Thomas, unanimously held that the Court of Appeals had abused its discretion when it reversed the district court. What was really important to the majority here, to the court, was the order of operations. The court made it clear that a plaintiff has to satisfy the extraordinary circumstances test of Rule 60B-6 before Rule 15A even comes into play. Until the court rules that the final judgment can be set aside, there is no active complaint to be amended. And moreover, the court here said that the district court had articulated a substantial justification for its denial of the motion to reopen when it cited the plaintiff's multiple refusals to amend the complaint when they'd been given the chance.
So what would you tell the lower courts about this case?
I would say, the Supreme Court is interpreting Rule 60B-6, as Erwin said, the catch-all provision, very narrowly.
So in Waetzig versus Halliburton Energy Services, the plaintiff Waetzig filed a Rule 60B-6 motion for relief from judgment again. Erwin, can you explain the issues in this case?
This was an instance where Waetzig sues Halliburton in an age discrimination claim. He then moves for voluntary dismissal of that complaint pursuant to Rule 41 of the Federal Rules of Civil Procedure, so the matter can go to arbitration. It goes to arbitration, and he loses. He now wants to go back to federal court, but in order to do so, he has to set aside the judgment of dismissing his case. And the question was, given that he voluntarily dismissed under Rule 41, is that a final judgment that would allow for a motion to set aside the judgment pursuant to Rule 60B-6?
So what did the court decide, and how did they come to the conclusion?
The question presented is whether a voluntary dismissal without prejudice, whether it constitutes a final judgment, order, or proceeding within the meaning of Rule 60B. The court held that voluntary dismissal without prejudice satisfies the definition of the term final. It terminates the action itself. And Final, the word final was meant to distinguish interlocutory, and certainly a dismissal can hardly be considered as interlocutory. Second, the court held that a voluntary dismissal without prejudice constitutes a proceeding. So the Webster's dictionary of the time defined a proceeding as a step or act taken in conducting litigation, which suggests that all steps taken in an action, including the filing of papers noted on the docket, are proceedings. Halliburton had argued that no, proceedings should be read as requiring some sort of act by the court itself, not a unilateral act by a party. But the court says that this proffered interpretation can't be right because the requirement of judicial action would create an overlap between the term proceeding and the term order in 60B, when the rule clearly contemplates them being separate things.
Okay, so in a nutshell, what do the lower courts need to take away from this?
Well, I think one of the interesting things is that the Supreme Court this term had two cases about Federal Rule of Civil Procedure 60b-6. And it's interesting to juxtapose the two cases because this case says he can bring a 60b-6 motion after a Rule 41 voluntary dismissal. But remember, the BLOM Bank case that we just talked about a moment ago said Rule 60b-6 motions should be granted only in extraordinary circumstances.
Okay. Thank you, Erwin. Thanks, Evan. It's been a pleasure talking with you today.